Good evening, everyone. Welcome to the special panel discussion on the occasion of World Day of International Justice by Girlup Ahsaas in collaboration with Girlup Sheisha and Girlup Bhiwani. Girlup Ahsaas is a Chandigarh-based club under the initiative of Girlup Campaign by UN Foundation, which focuses on girl education, gender equality, and empowering young women. I'm Vrinda Khanna, President of Girlup Ehsaas, and I'll be your moderator for today's events. We have gathered here to shed a light on the topic overcoming barriers and unleashing opportunities for social justice. Now, let me introduce you with the esteemed panelists for today's discussion. And we have with us Advocate Karanveer Singh, with the focus on criminal law, white collar crimes, finance, and commercial laws. Then we have Advocate Vishal Singhal, an independent practitioner with a focus in criminal law, constitutional law, and commercial litigation. We have Advocate Rajan Raj, who is a practicing advocate in Supreme Court of India and former partner of Luthra and Luthra. Then we have Miss Shivani Gupta, with the LLM graduate with a passion for intellectual property law and expertise in legal writings and patent law. We welcome you all the panelists.
Thank you. It's a pleasure to be
Thank
here.
you. Thank you, Vrinda. Thank you. It's a pleasure to be here.
Uh, as we know, human rights violation undermine the fundamental dignity and equality of all the individuals. Advocate Karanveer Singh, we request you to provide us with your insights on general overview about what human rights violation is and how it impacts our social justice.
Thank you, Vrinda. Uh, Hello, everyone. My name is Karanveer Singh. I'm an advocate practicing at Punjab Haryana High Court. I'll be beginning this evening's panel discussion and set the tone for the discussion on the topic of human rights violation and their impact on social justice, as well as how public international laws deal with the human rights violation. So, human rights, the fundamental rights and freedoms inherent to all individuals, are the bedrock of a harmonious society. However, when these rights are infringed upon, when individuals are subjected to discrimination, oppression, and injustice, it not only violates their basic dignity but also undermines the very essence of social justice. Human rights violations come in many forms. They encompass acts such as discrimination based on race, gender, sexuality, religion, or nationality. It also includes arbitrary arrests, detentions, torture and inhuman treatment, restrictions on freedom of expression, assembly and association, and denial to education, denial to healthcare, basic necessities. So each of these violations chips away at the principles of fairness, equality, and respect for human dignity that are crucial for social justice to flourish. Now, in India, we have a legislation called Protection of Human Rights Act 1993 as a protection for human rights as well as the Constitution of India, which confers fundamental rights upon all of us. Now, Section 2D of this act defines human rights as individual rights to life, liberty, equality, and dignity guaranteed by the Constitution or recognized in international governance and enforceable by Indian courts. Therefore, under the Protection of Human Rights Act 1993, the definition of human rights is firmly limited to the fundamental rights included in Part 3 of the Constitution, which are enforceable by the Indian courts. Now, historically speaking, the idea of human rights was first documented in the United Nations Charter, which emerged after the turmoil of World War II in San Francisco. That was in June 1945. Now, while this charter itself was not legally binding, it set forth a vision of ideas that would later shape the concept of human rights. Now, recognizing the need for the protection of human rights, the Nations General Assembly adopted the Universal Declaration of Human Rights in December 1948. However, this declaration uh, lacked enforceability as it was not legally binding covenant. It served more of a moral and ethical framework for nations to strive towards, but it did not carry the weight of law. To address this issue, the United Nations General Assembly took a significant step in December 1965 by adopting two covenants. These are one of the most significant covenants when it comes to the international human rights. One, the Covenant on Civil and Political Rights, and the Covenant on Economic, Social, and Cultural Rights. Now, the former covenant established legally enforceable individual rights, while the latter urged states to implement these rights through appropriate legislation. These covenants came into effect in December 1978. It took around 11 years for them to come into effect. And now after the ratification by member states, including India, which ratified it in 1981. Now, this journey towards the protection of human rights did not end here. In the early 1910s, when India faced international criticism for human rights violation committed by its armed forces in the state of Jammu and Kashmir, the pressure from foreign countries, coupled with the growing demand within the nation for addressing human rights issues, led to the significant developments on the domestic front. Now, in response to both international and domestic demands, on December 18th, 1993, the Lok Sabha passed Human Rights Bill. Now, bill eventually became an act in January 1994, the act which came into force in September 1993, which I earlier talked about. And this act was the first act in India which paved the way for the protection and promotion of human rights within the Indian context. Uh, Through these historical milestones, we can see the progressive journey of human rights from the ideals expressed in the United Nations Charter and the Universal Declaration of Human Rights to the legally enforceable covenants and establishment of national mechanisms to safeguard the human rights. Uh, Now, when we talk about public international law and human rights, with its array of treaties, conventions, and customary norms, public international law provides a foundation for the protection and promotion of human rights. Instruments such as Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, and the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment, among others, establish rights and obligations of states to safeguard the dignity and well being of individuals within their jurisdiction. However, despite the existence of these legal frameworks, human rights violations continue to persist in various parts of the world. It is incumbent upon the international community to address these violations and ensure accountability for those responsible. This requires collective effort, cooperation, application of public international law in its spirit and principle. Now, in cases of widespread and systematic human rights abuses, international tribunals and courts, such as the International Criminal Court, do serve as a crucial mechanism for justice. They do provide a platform to hold perpetrators accountable, deliver justice to victims, and establish a deterrent against future violations. Moreover, we often fail to realize that the diplomatic channels, multilateral institutions, and non-governmental organizations such as Girlup Ahsaas uh, play a pivotal role in advocating for human rights and raising awareness among violations. Now, through these diplomatic engagements, dialogue, and pressure, they work to compel states to adhere to their international human rights obligations. However, this is a lost cause today due to lack of political will towards human rights in international and national politics. It is imperative that states reaffirm their commitment to upholding human rights and strengthen their efforts to prevent and address violations. This includes adopting domestic legislations, establishing independent human rights institutions, and promoting a
Yes.
culture for respect of human rights within the societies. Also, to add, education and awareness also have a crucial role to play by fostering a deeper understanding of human rights principles and their significance. We can empower individuals to stand up against violations and work towards a world where human rights are respected, protected, and fulfilled. The impact of human right violation on social justice is profound. When individuals are denied their rights, it perpetuates cycles of inequality, marginalization, and exclusion. It creates a society where some have privilege and power, while others are denied their rightful place at the table. Now, this imbalance erodes trust, breeds resentment, and weakens the very fabric of our collective well being. Moreover, Vrinda, human rights violations have far reaching consequences. They impede social progress, they hinder economic development, and create divisions that threaten social cohesion. When certain segments of society are oppressed and silenced, their potential contribution to society are lost. They stifle in their innovation and creativity and their progress as well. It is only when every individual is empowered, when their rights are respected, protected, then we can truly achieve social justice and reap the benefits of a vibrant and an inclusive society. Yeah, I think that would set the tone for the today's discussion, and we
Uh,
would go forward through that. Yeah, thank you.
Thank you so much, sir, for your valuable inputs. Sir, as you rightly said about the general thing of what human rights are and what human rights violation is, it will be really helpful even for a layman. And sir, as you itself mentioned, like the public international law plays a significant role in addressing and remedying human rights violation worldwide by establishing a legal frameworks and norms. So, what are your thoughts on the same? Like, uh, uh, public international law is addressing a significant role and providing remedies. So,
Hmm.
what are your thoughts on the same?
Again, so public international law has the infrastructure to address the issues of human rights. However, it always boils down to political will. That is what I mentioned. The lack of political will is very significant when it comes to international as well as the national politics of today. So, when we think of the domestic structure in addressing human rights issue, again, political will is one of the fundamentals that needs to be considered. When we talk about international politics in view of the public international law, we do have the infrastructure, we do have covenants, they are enforceable. However, the question will always arise of the sovereignty of nations. Now, sovereignty of nations will always be subject to the political will of uh, their own. One sovereign cannot enforce a political will upon the other. They would hinder the sovereignty of a state. So yeah, we do have the infrastructure in public international law, but again, since there is a deterioration in the international politics since 1910, since we first documented and gave a structure to the definition of human rights, uh, it has only gone downward. Yeah.
Totally agree, sir. Thank you for your valuable words. So, as moving forward, we are seeing a backlash against the human rights all around the world, and the Universal Declaration of Human Rights are working to protect the basic human rights around the globe. So, I request Advocate Rajan Raj to shed a light on how human rights violation works in a global context.
Thank you, Avinda. So, on the topic of human rights, human beings are entitled to certain basic and natural rights that define a meaningful existence. These rights have been designated to be universal in application, inalienable in exercise, and inherent to all persons. As natural rights are intrinsic and independent of rights provided by the state government, the state is merely a guarantor of these rights and not their fundamental source. Thus, even the state cannot take away their rights, nor can any person or institution waive these rights by virtue of the inalienable nature of these rights. The American independence movement of 1776 and the French Revolution of 1789 were inspired by the ideal of natural rights and challenged governments that curtailed the natural rights of people. Thus, the American Constitution, as well as the French Declaration of Rights of Man, formulate these pre existing basic human rights which people have declared for themselves. The Universal Declaration of Human Rights emerged as a reaction to the atrocities and oppression caused by the Second World War. The Universal Declaration of Human Rights was the first international acknowledgement of the inherent dignity and equal and inalienable rights of all humans as the foundation of freedom, justice, and peace in the world. The UDHR, in whose drafting different countries with varying cultures, beliefs, and stages of development were involved, has political as well as social and economic rights to reflect the aspiration of the newly independent countries at that time, like India. The Indian Constitution exemplifies this common understanding of basic human rights as it incorporates the principles outlined in the Universal Declaration of Human Rights in the form of fundamental rights and directive principles of state policy. The Universal Declaration of Human Rights was premised on the principle of universality and non discrimination. The rights and freedoms contained in the Declaration were available to all, irrespective of their race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. As the UNHR was in form of a declaration and not binding, the UN General Assembly in 1966 adopted the two treaties, International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights, which when ratified by a state become binding on it. These treaties form the International Bill of Rights and have laid the foundation of formulation and adoption of human rights treaties relating to equality, non-discrimination, education, health, social security, administration of justice, social development, violation against women, status of refugees, minorities, etc. The universality of human rights is often challenged on the basis of cultural economic differences arising from a north-south global divide. The southern countries argue that societies in south are ordered on lines of community. The rights and identities of individuals are subsumed by a larger interest of community. Some Islamic countries have recorded reservations against certain provisions of CEDAW, that is Convention of Elimination of Discrimination Against Women, on the ground that it is in conflict with Islamic law or Sharia. Human rights have to be developed within understanding of specific culture, community, and traditions. It is not a frozen concept, but a dynamic principle capable of adapting within a complex, varied, and changing global environment. Part 3 of the Constitution of India has fundamental rights, which Supreme Court in Golak Nath versus State of Punjab, AR 1967, SC 1643 held are the modern version of human rights. These rights are available to persons and citizens with a corresponding duty on Indian state and instrumentalities for implementation and protection. The fundamental rights are not absolute in nature and can be subjected to reasonable restrictions. India has ratified several human rights conventions. Article 51C of Constitution requires state to endeavor to foster respect for international law and treaty obligations. The Parliament, deriving powers from Article 253 of Constitution, can enact laws in order to incorporate the provisions of treaties within India's domestic legal framework. For example, in Vishakha versus State of Rajasthan, 1997 6 SCC 241, the Supreme Court filled the existing void in domestic law with respect to prevention of sexual harassment in workplace using provisions of CEDAW and laid down guidelines to be followed in the workplace. The court held that so long as international conventions were consistent with fundamental rights and in harmony with its spirit, the same must be read into the Constitution to enlarge the meaning and content thereof. Thus, human rights jurisprudence is a constantly evolving field, and we as lawyers observe it on a daily basis and on a case to case basis, whether it be by way of public interest litigation or even in a criminal case where the guilt of an accused is decided by the court. Human rights jurisprudence is always at play. It is not a specialized field which is for some lawyers, but it is an all pervasive field which concerns us on a day to day basis as lawyers as well as citizens of a general society. Thank you.
Thank you, sir, for your insightful words. So, sir, it is rightly said by Justice Anand, former chairperson of the Human Rights Commission, that as a state, to ensure that everyone has the right to adequate food, education, and enjoyment of highest sustainable standards of physical and mental health. These rights have to be respected and made available to all the citizens of the state. So, Advocate Rajan, I request you to share your thoughts on human rights violation in Indian context.
India as a developing society with huge gaping economic inequality as well as pervasive oppressive structures of caste, communalism, gender, faces teething problems in guaranteeing basic human rights to a large section of its society. The political class also is largely not responsive to the needs of the teeming millions of this country. We as lawyers, in our limited way, can help to guarantee these rights. But as was said by the earlier speaker as well, unless there is a political will and the society as a whole, the civil society, wakes up to its responsibility that if basic human rights are not guaranteed to the mass of people in this country, there will be no lasting uh, prosperity, development, or peace in this country. Till that realization and till that sensitization of basic human rights pervades our society, we still have a long way to go till there. Thank you. Vrinda, are you there?
Sorry, sir, I faced some network issue at that moment.
No problem. So I have concluded my segment.
So, thank you so much, sir, for your valuable words. So now let's move on to the individuals whose rights are violated. So I we have seen stereotypes and gender discrimination resulting therefrom, as well as high cost in terms of development as well as human rights. Ms. Shivani, can you please share your thoughts on gender stereotyping as human rights violation in a male dominating society?
Thank you, first of all, Ms. Brinda, to calling me on this platform, Girlup. Good evening, everyone. Shivani Gupta here from Radabad. I'm a visiting faculty of law. See, today the discussion topic is about how the stereotyping things are affecting the women rights across the globe. When it's come about the across the globe, then we have to discuss the things at the global level with reference to the UN provisions also. There was a research paper report that was published. Am I audible now?
Yes, ma'am, you're audible.
Okay, there was a research report also published and the project also delivered. There are certain examinations being done by the international human rights treaties, international human rights mechanisms, that is, we can see human rights treaties, human rights bodies. They just identify, they just try to seek some of the points regarding defining key concepts of gender stereotyping, what the gender stereotyping is. They identify the MAP international human rights obligations, and they also identify certain issues related to the gender stereotyping, particularly sustaining in our society. The report and research being made to analyze how, in view of the international based UN human rights mechanism, the gender stereotyping harm the women across the globe. In doing so, that research and the report particularly aims to identify potential opportunities and the challenges that on the work by the OHCHR or the gender stereotype that particularly aims to make the normative development of the human rights obligations related to the gender stereotyping that are laying a robust foundation of further research for the gender stereotyping. Look, when it comes to the gender stereotyping, in particularly of the case of the women in the male-dominating society, then there is a kind of a persuasive human right violation. As we can see around ourselves also, it's a frequent cause of the discrimination against the women only, and the contributing factor in the violation of human rights, ranging from we can say right to an adequate standard of living through to the freedom from the gender-based violence. Yet, despite that substantial harm they have caused, gender stereotypes and gender stereotyping are often misunderstood as the gender human rights discourses. This is not true. It's significant for the instance that the gender stereotyping is regularly overlooked as the cause of the human right violation. Gender stereotypes are frequently misidentified if they are identified at all, and there is a little depth discussion also that must lead to the merit in which the gender stereotypes and gender stereotyping are actually harming the women. Moreover, there is also a fact that it's not about the international human rights treaty itself to impose certain obligations related to the stereotypes, or we can say stereotyping. It's in spite of the fact that many human rights treaties at the global level have recognized that the rights of the non-discrimination and the equality also, and through them other rights of this such as the freedom right containing and implied kind of obligation are also need to be addressed that are being as harmful as the stereotyping, or we can say the wrongful stereotyping. There are when we discuss about on the occasion of International Justice Day, we can say that a human rights mechanism, notably about the committee that is being formed and known as the CEDAW committee, a committee on the elimination of discrimination against the women, that have increasingly shed important light on the grave or the systematic harms of the gender stereotypes and the gender stereotyping. The working mechanism at the global level has already helped to propel the issue of gender stereotyping onto the international human rights stages, and has been an important factor that has helped to encourage other mechanisms to give this issue a serious attention. Important groundwork we can say on this day is that there are mechanisms that are being helping to move the conversations. First of all, the conversation is all just required to make the issue in the mainstream, and gender stereotyping is into the next phase. One is where there is a widespread understanding of the key concepts of the gender stereotyping, and a keen and sophisticated awareness is much needed. That is of a broad ranging stereotyping and a keen kind of international human rights obligations related to the stereotypings at all. But for now, if we look at the ground reality, then how much work is needed to be prioritized regarding the stereotyping and all as a human right is a great concern for the day. So in this era, we can say at the present, there is a most important and the significance requirement of the leadership role for the offices of the High Commission regarding the human rights at all at the global level. Now, when we discuss about there is a leadership role on the gender stereotyping, then there must be the extension of the work supporting the treaty bodies. Now, the first is that we can take it about the developing the general recommendations on the obligations of the state parties itself to address the stereotypes and their related stereotyping. There is a committee known as the OHCHR that also should giving consideration about briefing note on the stereotypes and stereotyping existing all over the world, and there are certain incoming experts also who are just appointed by the Human Rights Commission and the treaties body to treat such issues. Moreover, the body OHCHR at the global level also advocating the annual meetings of the chairpersons of the human rights treaty bodies to consider there is a fact like harmonization of the treaty body approaches to the harmful stereotypes and the wrongful stereotypes. Just like with the treaty bodies, OHCHR can show also trying to show the leadership on the stereotyping through its work that is being supporting the special procedure to the Human Rights Council at the global level. So since if we talk about particularly the things related to the India, so gender stereotyping in our country is still sustainable, still the things are existing, and it's about when we talk about the Constitution of India, then right to equality is much more paying the reward to eradicate the gender equality from the society. That's all, ma'am. Yes.
Totally agree with your valuable words, ma'am. Ma'am, moving forward with the same
Thank you.
topic as we are talking about individual violations, so I want to discuss about minorities such as LGBTQ plus community, tribes, refugee, etc. We learned that
Yeah, same in
respecting
the
and
yeah.
Ma'am, we learned that respecting the rights of minorities is essential for upholding the principle of equality and non-discrimination. So we want to know your thoughts on the same.
Yeah, ma'am, we discuss when we discuss about the stereotyping, then it's not only just restricted to the women or the children of the society. It's not the gender bias thing. It's just restricted to the all other genders or all other part of the people of the society who are other than the male. When we discuss about it's a male-dominating society, then we are discussing about the violation of the rights of other communities of the society. Either it's the women, it's the children, it's the minors, it's the minorities, it's the LGBTQ. We agree for the same. Stereotyping is there, and there is a constitution is working hard upon the same.
Thank you, ma'am. We totally agree with your words. So, like as we
Mhm.
see, like society is rapidly embracing to digitalization, transforming various aspects of our lives, and both opportunities and challenges, leading to the new form of human rights violation in the digital sphere. So, I want to request Educate Vishal to share your views on the same, like how the digital disruptions of leads to violation of human rights.
First of all, thank you, Brenda, for inviting me to such an insightful session. I would like to start by stating one very statement that in today's world, there has been no distinction left between a person sitting online as well as a person who is meeting physically with the other person. For the three reasons. Basically, first is the big data analytics, like the data is used by big tech companies such as Facebook, Twitter, your identities, and everything. Second, I would like to come to the point of algorithms that are being used by the government to facilitate services to the citizens as well as the across the borders as well as in the public and private sector. Third, I would say that today's world, AI and machine learning has been on increase, on an incline, for the sole reason that today we trust machines more than human beings. Best examples can be from the US. Tesla is building cars which are which don't need any human intervention and they can just run on the main roads. but I think on Indian roads that would be a bit difficulties. Coming to the second part, that is the digital technology today has become a double-edged sword. That is, it helps in promoting human rights or exercise of human rights such as freedom of speech and expression. At the same time, it also has become a means for the violation of human rights. Now, coming to the third aspect, now the question arises is, can HR framework or the human rights framework remain relevant in the new cyber space, considering the territorial issues? And there has been a statement I would like to make by John Perry, who stated that in cyberspace there is no sovereignty of the government. So that is, I think so is a big issue in today's world. If government cannot exercise their sovereignty in cyberspace, that will clearly create issues for national security. Now let us go to the principles as highlighted by Mr. Karanveer on the principles on which the UN was established So one of the principle or the basic pillar was human rights and their enforcement across the borders. Coming to the issues as a result of which the digital technology has faced today, the first thing is the trans-border nature of internet that, as I have highlighted, the statement by John Perry. Now, as a result of which, there are a lot of privacy violations. Like, for example, in a recent news, you must have heard that the server of the AIMS Hospital, Delhi, was hijacked by some cyber hacker, right? So, hospitals are something wherein a lot of credible information as well as private information of an individual is being stored by the doctors. Secondly, it refers to the identity theft, creating issues of identity theft. Like I, my personally, if I speak, like there has been my fake profiles over Facebook and Instagram, which I have reported, of course, to the police authorities. But identity theft is another issue which leads to, which with the advent of digitization. Third is the misinformation that is being circulated over the internet. For example, the Shaheen Bagh rights, which due to the CAA Amendment Act brought by the government, a lot of information was in fact circulated on Facebook, which was misinformation or which was not related to the facts of the case. And now, third, now the second leg is the digitization of everything. We have today digitized everything, like from me going to gym, walking, my heart rate, my pulse rate, everything is digitized. As a result of which, everything is being tracked, can be tracked by the governments or by private spectators. They decide where I go, what I choose, and in fact, on based on those preferences, they give me the new ideas that I should try this or that based on my search histories. Now, third thing, and one of the issues of digitization of everything leads to the unchecked digitization. Like who is going to check this digitization? Third and the most important one is the privatization of government. Today, Facebook like websites or the multi-tech companies like Facebooks are becoming state actors because some or the other way they are performing state-like actions. For example, the public functions, they are circulating news over there in the nature of post over Facebook. And now who is going to check those informations? These recent examples can again be tracked to the CAA protest, wherein Facebook, when the Peace and Harmony Committee was constituted by the state government of Delhi, the Facebook was summoned. However, they dodged this summons and they stated that we are not compelled and we cannot come to you and help you out with this. Another controversy leading to the privatization of governance can be the FBI and Apple issue, wherein FBI asked Apple to share the or unlock the Apple iPhones of the terrorists or the people who are using those phones. Now, coming to the another issue is like, as we all know that corporate entities are ultimately profit maximization industries, and therefore the question comes of monetization of data. Today, data are much more being sold to terrorist organizations or other organizations for whatever purposes. So we are being tagged every moment, considering how today's society is functioning in digital economy. So my suggestion would be that with every advantage there always comes a disadvantage, and technological advantages are always there, but at the same time there are disadvantages. Now, coming to one of the major issue of human rights is the increasing inequalities. Increasing inequalities in the sense that we had a sustainable development goal that there will be access to internet across the globe by 2020, but we are far from reaching that because today If I go into the facts, like 65% people in the developing countries are not even aware what internet is. And talking about the world, out of 10, 6 people are not even connected to the internet. So now you can understand whether we are able to uh, adhere to what our sustainable development goals were. And then comes the third and the most important fifth and the most important aspect, that is the violation in the name of state security by applying various vague cyber laws. Best example could be the Shivani Singhal case, wherein she was arrested for sharing a Facebook social media post, as a result of which Section 66A was turned down as unconstitutional by the Supreme Court of our country. So now coming to the arbitrariness in the age of digitalization, and how does it lead to human right violation? So what does arbitrariness refers to? So for me, arbitrariness refers to a law which is not supported by fair, solid, and substantial cause and without reason. So basically, it means unreasonable use of power. Right now, let us go to Article 7 of the UDHR. What it says? It says that all are equal before the law and everybody is entitled to equal protection of law without any discrimination. So it's a blanket clause. But let us go to now Indian Constitution Article 14. What it says: the state shall not deny to any person equality before law and equal protection of laws within the territory of India. So we have somewhat used that terminology. We have taken terminologies from the US Constitution, of course, the British Constitution, and then we have decided as to in which way we are going. Now, how arbitrariness leads to HR violation? It actually leads to lack predictability, it lacks credibility, consistency, and fairness. Now, I'll give you a four basic examples with respect to the same. Now, for example, selective applicability of laws leads to arbitrariness. For example, UAPA. Anybody can be arrested under the law without telling him the reasons, and he is under prolonged detention without any court or order, magistrate's orders. Secondly, the Citizenship Amendment Act. It, as stated by the people, I have not gone through the whole, but what has been stated you on social media, Facebook media post was that we are forgetting that we are a tolerant nation, and the Muslims have been left aside from the Citizenship Amendment Act, like they cannot come to India, they cannot get citizenship, etc., etc. So this things also leads to arbitrariness. Now, second part of the arbitrariness would be the lack of procedural equality. How come procedural equality? Procedural equality flows from the principles of fair trial and due process of law, or as we have used procedural established by law in our constitution. Now, for example, you can procedural equality can be the lack of procedural safeguards for the detainees or the people who are suffering at the hands of the state actors or the non-state actors. Best example can be in international arena could be Kulbhushan Jadhav case of ICJ, wherein India has approached the International Court of Justice alleging that the Pakistan has violated the right to consular access that is to be provided under the international humanitarian law, right? And later on, what happened? ICJ ruled in favor of the India. Therefore, Pakistan was a violator of consular access, which is a prerogative, and at the same time, access to justice. Third would be the freedom of speech and expression. Now, one important aspect that is debated in the 21st century under this right is right to be forgotten. That supposedly, if there is a court case going against me, it has been reported by Google, India Kanun, or whatever in our country. Am I eligible to be forgotten from their database, and whether I will be appearing in the search results after the court case has ended, right? Supposedly, most of the time, what happens is if supposedly there is some top-notch figure, like for example, today I say anything about Mr. Modi, so if those allegations are not proved, are those allegations going to be removed from Google? Is what right to be forgotten is all about. The best example again could be of Google, the U declaration, wherein a person alleged that Google has been using his name again and again, even after he has paid all the personal debts and everything, him of his liabilities. But his name was again and again appearing before the search results. So it is actually impacting his reputation, which is an important aspect of individual dignity, protected by right to life. Last and the foremost would be the contribution, and arbitrariness also leads to contribution to torture. How come? Like, for example, a democratic democratic candidate in Myanmar was arrested and put to house arrest for almost 15 years without telling her the charges, leading to torture, leading to affecting her right to life and liberty. And at the same time, everybody will be aware about the Guantanamo Bay issues in US after the 9/11 attacks, wherein certain people were put in under trial without telling them the charges. They did not face the trial, and there were also inhuman conditions under because those were not checks and balances. So with this, I would conclude that with the advent of digital technology, it is us who has to be careful while using digital technologies in today's 21st century. Thank you.
Thank you, sir, for your valuable words. Now it's time to conclude our panel discussion. So we have to move to the question and answer session, and I encourage our audience to actively participate by typing their questions in the chat or comment section. Panelists, please be ready for the question and answer round. So, sir, our first question is what are the most pressing human rights violation in the world today, and what are the factors that contribute to their persistence?
Uh, when we talk about the most pressing human rights violation in the world, would the new, as Mr. Vishal was talking about, the, the new kind of violation that has taken over the world is the digital violation. uh, the first and foremost being the privacy that is being hindered. Everything is being, for example, this panel discussion is being recorded, and algorithm is discussing how to marketeer this. So I'll give you an example. There's something called neuromarketing. So neuromarketing is something at how people perceive things, and how would they want to buy things. And they take data from how we use our phones, we use our laptops, how we basically function in our day-to-day lives. But that data is being collected without even taking any kind of consent from the individuals. And this is one of the most it is one of the kind of violation which is not being talked about. And I think that should be a pressing issue. It isn't a pressing issue, because we have issues like illegal detention. We have issues like uh, basic human rights violation, like not providing clean water to people. Because since we have those issues, we can't jump to issues like right to privacy, especially in developing countries and the underdeveloped countries, right? So I think that are one of the most pressing issues that need to be addressed, and not being, and time and again are not being addressed. And one of the factors that contribute to such persistence of these issues, I would say, one, as I mentioned, political will. Two, I think in some way it benefits the big corporate, the big pharma, the if you talk about the, the the capitalist market in that regards. So violation is actually uh, in favor of the one person, and that is what persists. That is what makes the human rights violation persist, I would say. And another factor that contributes to non catering to the social justice would be uh, it just skipped my mind, I'm sorry. uh, it would be that, one, that there is no political will. Two, that it benefits the capitalist market. Three, that there is a certain ignorance from the masses towards the downtrodden, towards the people who don't have, who are suffering. So for example, if I am the one who is suffering today, the civil society wouldn't come forward and speak against me. The civil society would keep mum because they have incentives to keep mum. They have incentives in a way that if they keep mum, their human rights wouldn't be violated. So it is a system of to and fro that is strategically being developed in the all across the nations. It's not just in India. It was internationally. I think these are the most three most significant factors that make the human rights issues persist. Yeah. Thank you.
I totally agree with you, sir. So, what are your views on it, Advocate Vishal?
Vrinda, adding to what Karanveer Singh stated, another very pressing demand or the issue with respect to human rights is the refugee crisis. Like we all are aware that today India is not a party to refugee convention. But the question that comes while signing an international document is always with respect to, of course, it lies in the liberty of the state actor, right? It lies in the liberty of the government. The problem comes when you have to balance the rights of general public at large and your citizens at the same time, right? Same pressing issue has been arising in India for a longer period of time. You must have seen news articles and many issues like there is a lot of influx in India is with respect to refugees. Recently Afghanistan crisis were going on, Ukrainian crisis were going on, then the Myanmar crisis, of course the Rohingyas, and some way or down the line the Sri Lankan crisis where a lot of Tamilians flew to India, right? The problem comes when you are balancing the human rights of all the refugees and the citizens as a whole, right? Today, India in itself is suffering through a lot of issues, including the poverty thing, including the economic capacity, the per capita GDP. Today in India, we are not able to provide two square meals a day to a below poverty line individual, right? We can always argue many issues such as like should be technology, there should be AI brought to our country, there should be bullet trains in the country, but what about the balancing of the rights of the general public? Because ultimately there is a there is a theory called social contract theory, right? The basic underlying principle of social contract theory is that certain power, like ultimately government functions on the will of people, right? I have taken my power. A part of say 10%. I have given it to a third neutral party, and I have said that now you are the protector of my right. This is how social contract theory functions. But the refugees, whether they have granted those powers to our government, no. What about our rights? What about their human basic dignity rights? So this is one of the pressing demands that the political will of the government has to decide. Second would be with respect to the issues of, I would say, the secularism issues, the misinformation associated with secularism on international arena as well as in domestic arena. Why I'm saying this is countries like Pakistan, Iran, Saudi Arabia, Afghanistan have blasphemy laws, right? They follow one singular religion. India is a secular country, but we also have to differentiate between the inclusivity and exclusivity of the society as a whole. Secularism in today's world is understood as a concept where state does not have any religion. But me, particularly, I am a Hindu by my religion, right? I have my own thoughts, I have my own beliefs. That right has been granted by the Constitution. So at the same time, I have to balance those rights also with the other religious people, right? I cannot violate their rights also. And in the same time, internationally also the same thing happens. So with this I would like to conclude, so these two issues have to be addressed by the government at large scale so that a large scale human rights can be protected, or the rights could be protected.
That's a really valuable word, sir. Miss Shivani, do you want to add something on it?
Yes, Brenda. When we discuss about confronting the stereotyping, my learned colleagues had discussed about the refugee issues, cyber threats, and the privacy issues. But here, as a woman, I would like to discuss about the women stereotyping particularly. In this context, when we discuss about the confronting the stereotyping in the modern era, then what we can say that there is a need of a transitional legal approach that is being much needed. That would like to encourage the translation of the international human rights treaties also in the context of the Indian human rights also. And there are certain domestic laws as regarding the protection of the women writing regarding domestic violence. Protection of the women from the domestic violence, either it is the maternity relief act and other there are. Then there is a requirement for the fostering the development of the comparative legal analysis to confront the issue. Next, there is certain need of the law and the policies that being to acknowledge that the society sanctions the women who didn't even confirm the stereotypical rules and take the measures to protect them. See what Cook and the Cusick recommend American jurists that the government courts and other authorities take more time and care to identify the stereotypes at the same time prevailing in our society. A case presented to the American Commission also for the same, where there is a law that is giving the men the power and the responsibility to financially sustain the marital home, whereas publicly represent the marital union and administer the marital property. Whereas when we confer about the married woman, then it's the right and the obligation of the women also only to take care of the children and take care of the marital home. So it's a kind of inequality that is prevailing around the globe. Now, the authors also regarding the legal analysis they are publishing recommend that the states itself must undertake certain assessments of what measures should be particularly appropriately done to dismantle or eliminate the gender stereotypes that are being prevailing in our society. The measures could include the training of the judicial, administrative, and the parliamentary officials also on the stereotypes and the stereotyping itself. And those effects will prevail as a disadvantage by them evaluating the laws and the policies that reinforce stereotypes and proactively confronting the overtuning the social norms to promote the gender stereotyping, especially in the case of women and the children. I would like to conclude my thought with the one thought that the authorities or the authors of the legal literature must really proactive in identifying the gender stereotypes and prescribing the measures to address them at large. We can say that there are certain literature regarding the feminist jurisprudence also that can be the useful tool for the women's rights advocating to work with them, and outside the government also there are certain NGOs doing the same. Thank you.
Thank you, ma'am, for your valuable insights. Now, I want to ask, like, what are the major challenges in enforcing human rights standards in different countries, particularly when they have different cultures, different political backgrounds, and different legal framework or legal system? So, Advocate Vishal, what are your views on the same?
Vrinda, can you just please repeat the question once?
Sure, sir. So, sir, our question is, what are the major challenges in enforcing human rights standard in different countries, particularly when they have different cultures, different political backgrounds, and different legal systems?
So, Vrinda, starting with the different cultures and everything, as a result of which one major issue that arises is the subjective nature of the human rights. If you would go through UDHR, if you go and give a cursory reading to it, it is very subjective in nature. What is equal for you might not be equal to other panelists sitting over here, and what is just for us could not be just for you, right? So there will always be some of the other indifferences with respect to protecting the people from human rights violation. What we could do is to have and sit together as stakeholders like lawyers, judges, uh, environment experts, like UN think tanks, UN, and others, and then we can decide what is to be done with respect to the changing needs. Another issue comes with respect to the multinational or the corporate or the capitalist mindset companies like Facebook, Twitter, and everything. Like you would see, like Facebook has been summoned in almost every parliament of the country. For example, like Canada has summoned Facebook, British Parliament has summoned Facebook. The Legislative Assembly of Delhi has summoned Facebook. So the characteristic has to be of a multinational company or a social media platform in digital times. has to be regulated by the government. There has to be certain rules, regulations, policies with respect to the same. And with respect to the different cultures and different personalities of the people, I think so. If we have given our a will to the government to decide what is good and bad for us, what is just and reasonable has to be decided by the government with respect to the same. Because if we go with individual preferences, I think it will cause a hue and cry in the society and a havoc in the society. So, with this, I conclude.
Okay. Thank you, sir, for your words. Advocate Karanveer, please add on.
Yeah, I would say even in different cultures, if if we have rule of law as a supreme, I don't think we would have an issue with enforcing human rights. But since in most of the cultures, enforceability of rule of law isn't that effective as it is in certain other countries. I think that is one of the hindrance that needs to be balanced in different jurisdictions. Another is there is no public participation and transparency in how uh, different cultures take over deal with the human rights violations. So I think again, how Vishal added, there is a need for all stakeholders to sit together, and especially when it comes to human rights, that we established a mechanism, a structure wherein all the cultures are inclusive. However, there is a balance between different. There is a balance between individual uh, human right protection as well as the societal human right protection.
Thank you, sir, for your words. Ms. Shivani, can please add on for the same?
Yeah, yeah. Thanks, Linda. As my learned colleagues also said the same, so I agree to the same thing. I would like to say that to eliminate particularly gender-based violence against the women or against the weaker section of the society, either it's we can say minorities or the LGBTQ, then it would be crucial to transform the discriminatory gender norms and stereotypes and to promote the non-violent, respectful, and equal gender relations between the men, women, and the non-binary persons. Measures such as the responsive early childhood education and the development, the integration of the gender equality content into the curricula at all the levels of the education, promoting equal sharing of the responsibilities in the unpaid care and the domestic work, etc., may be prompted. And I think these are the things that could we can eradicate the harmful gender stereotyping from the society to the extent. Thanks.
Totally agree with you, ma'am. Gender equality is necessary for promoting human rights. So, my next question is what are the most significant human rights violation faced by the men in the case of sexual assault or domestic violence as a victim? How can society and legal system make it better to address? As we can see, like most of the people talk about women rights, children rights, but nobody is clearly talking about the rights for the men. So I want to know your context on the same.
Uh, Vrinda, I would like to start by stating very important fact as Madam Shivani Gupta has stated. Gender neutrality is must in whatever country we go, be it US, be it UK, be it Canada, be it US, be it India. Funny aspect today is, and frankly speaking, being a practicing advocate, I can see the realities of law in day-to-day courtrooms. Like, for example, today if a wife wants to go and seek divorce in courtrooms, to create a sense of pressure to get a hefty settlement, they also go parallelly in domestic violence proceedings against the husband, whether or not the same has been committed or not. Thankfully, Supreme Court in one of its judgment had said that the police officials shall be conducting a preliminary inquiry before arresting the husband. That is sending a 41A notice to the husband. But in most of the cases, what happens is like, for example, if there is a domestic violence complaint against you, for example, against me. So first thing the police has to do is send me a notice or someone to appear before him and tell him my side of the story as to what has taken place. But in reality, what has taken place is they directly ask you a question: Are you taking your wife home or not? This is the first question that is being asked by a police official in a domestic violence case. Second thing is, they don't even go for an MLC or whatever. They directly ask the women, give us your medical history, we will go through it and we will frame a case so that both the police officials can get benefit out of it. And of course, gender neutrality, no offenses to any female sitting over here or across the country or across the globe. But trust me, gender neutrality is must. Before, without that, you can't achieve anything. That is first thing. Second thing is now coming to the men as a whole. I'll take a real life example. A few days back, I received a query with respect to Muslim divorce. How a Muslim person can get a divorce. Funny part was there was nothing in the law as provided in the Hindu Marriage Act or otherwise. In Hindu Marriage Act, a husband can also apply for a divorce, a woman can also apply for a divorce. Grounds are already given. But in Muslim personal law, there is no provision of law through which a Muslim can directly approach a court of law and seek divorce from his wife. And then comes the triple talaq issue. Again, it's favoring one and not favoring the other. Hefty punishments, and this is how, and therefore the debate has come across like personal laws is one of the issues which has to be curved, and majorly human rights violation takes place from personal laws when it comes to gender neutrality part. Coming to the UCC part, which I think so, there was a question also how I see UCC. What we have to see in UCC is how we are going to implement it, because everybody has their own customs. Those are protected under Article 25 of our Constitution. That is the freedom to practice, profess, and worship. Right? Those are protected. So, like for example, in Sikhism, the ritual to get married is different from an individual of Hindu community getting married. Right? At the same time, marriage ritual in Muslim personal law is different. So, how are you going to balance these issues when you are talking or debating UCC in our country? So, this is something that has to be debated instead of debating whether we need an UCC or not. Okay. So, with this, I conclude.
Yeah, adding to that, Virendra, when we talk about men's rights, so there is always an adverse effect of a pro individual, pro group act. So when you have pro gender acts, for example, pro women act, there's always an adverse effect on the in the other gender, right? For the sake of this discussion, I'm considering these genders because that is how what the law is identifying now. So when we have a pro gender act, it will always have an adverse effect on the significant other gender for which it is against. For example, when you have a DV Act, which is supporting women. Uh, when you have a 125 Maintenance Act, which is supporting women. When you have Hindu Marriage Act Section 24, which is supporting women, there will always be an adverse effect. So when this when we start talking about, the funny thing is we start talking about it when it peaks, right? When it peaks, there is disbalance. Now we start talking about it. So when we talk about it, there is a balance again. As to once we talk about it enough, when you talk about it enough, it goes to Supreme Court. Supreme Court considers it. In the Lok Sabha, there is a debate around balancing of laws between men and women and other genders. Then we realize that then we come to the conclusion that no, the laws are biased. We need to be protecting the others too. However, adding to that, there are there is a difficulty here. The difficulty is there are still women who are not reaping the benefits of the pro women acts. That is also a difficulty that the legislation would have to recognize. For example, again, as Vishal said, we deal with laws every day in courts. 376 offenses are being held upon just like that in consensual relationships. the victims of rape are still not getting justices. The victims of domestic violence still don't have any benefit from domestic violence act. I would go to the extent of saying that violence act as a statute, as a structure, has failed. How? Because how does it function? I would go to the extent of saying that it is not even functioning properly. Uh, the Section 12 of the DV Act says that you issue legal notice to the husband, or any women, if any women apply to the court saying that I have been a victim of domestic violence, and they send a legal notice to the different man. The the court doesn't send a legal notice. The court sends a summon, and once the summon aren't service and the person doesn't appear, bailable warrants are issued again. So the purpose of DV Act was to reconcile marriages, not to disrupt marriages, not to coerce people into taking hefty amounts, right? So these are difficulties that are significant. I think the policymakers would have a hard time balancing it in a diverse society like India, where the benefit isn't going to the NH person, and the benefit is being taken advantage of by the privileged. So these are two. This is one factor that needs to be considered when you have to consider men's rights, right? So yeah, I would conclude at that.
Thank you, sir. Ma'am, kindly share your views on the same.
Ma'am, there was a report published in a journal where the 42% of the digital gender gap, we can especially say in India, is often linked to the social norms regarding the blast and the gender stereotypes that being the perceived girls are inherently talked about. That is that inherently not tech savvy, and men discourage them, the girls, to pursue education and the engineering and mathematics fields. Women are often hold back from the high status positions in the society. That is also affecting a particularly women's self-image and may to hold some women back as the count themselves out of the pursuing prestigious roles in the professional field, as they believe that they won't excel in despite having the skills to succeed. There is one more thing that the persistent gender gap in the education, either employment and the wages is also due to the part of the gender stereotyping itself. One more thing we can say to the making the conclusion of the fact is persuasive stereotyping is that because the women itself are considered vulnerable and emotionally volatile because they are incapable of making the rational decisions, it's somehow being believed due to their reproductive capacity. It also denies to the women in front information to make informed decisions. Is the major concern nowadays, and those healthcare in the particulars. Now, harmful gender stereotypes, rigid construction of the community, and the masculinity and the stereotype gender roles are the root cause of the gender-based violation, as per my views, against the women itself. That's all from me.
Thank you, ma'am. Thank you, everyone, for your active participation in this enlightening panel discussion. I would like to express my
Thank you.
sincere gratitude to our esteemed panelists, Advocate Karanveer Singh, Advocate Vishal Singhal, Advocate Rajan Raj and Ms. Shivani Gupta for their valuable insights and knowledge with us today. Remember, social justice is a collective responsibility, and by addressing barriers and embracing opportunity, we can strive towards more just society. So, thank you, everyone, and we
Thank
wish you again happy World Day of International Justice.
Thank you, Brinda. Thank you. We wish the same to you, and congratulations on a very healthy panel discussion. Thank you.
Thank you,
Thank you.
sir.
Thank you, Vrinda.